Cian McGettigan, student number 193717. Unenumerated rights are legal rights inferred from other rights that are implied by existing laws but are not themselves expressly coded or enumerated among the explicit writ of the law. Emerging in the 1960s and gaining significant judicial support throughout the 70s and 80s, the doctrine of unenumerated rights has been one of the most innovative and controversial measures adopted by the Irish court to recognise rights since its formation in 1907. Since the decision of Kenny J. in Ryan and Attorney General in 1965, the courts have recognised as many as 20 unenumerated personal rights which fall to be protected by Article 40.31. These rights include the right to earn a livelihood, the right to privacy, and the right to found a family. Some rights are described in absolutist language, for example, the inalienable and imprescriptible rights of the family, whereas other rights are expressed in highly qualified form. While the development of the unenumerated rights doctrine has in many respects proved to be beneficial, unease has also been expressed. The Constitutional Review Group Report 1996 found that the list of rights expressly protected by the Constitution is, by contemporary standards, incomplete. Even a right which is virtually universally recognised as fundamental in a civilised society, such as the right to travel, was not expressly protected by the Constitution as originally enacted. Some of the difficulties presented by an incomplete list of rights have been ameliorated by the development of the doctrine of unenumerated personal rights in Article 40.31. A comparison of the language of Article 40.31 with that of Article 40.32 suggests that the drafters never intended that the list of rights expressly enumerated by the Constitution would be exhaustive. Therefore, this doctrine is essential. The power of the state to delimit the exercise of constitutionally protected rights is expressly given in some articles and not referred to at all in others, but this cannot mean that where absent, the power does not exist. This suggests that the doctrine is of high importance, as not every right should have to be explicitly mentioned in the Constitution in order to be protected. The Constitutional Review Group recommended that the Constitution should be amended so as to expressly recognise rights already identified. While this recommendation was never implemented, the practice of the appellate courts in the intervening period has amounted to much of the same thing. NHV concerned a challenge by an asylum seeker to Section 9.4 of the Refugee Act of 1996, which provides that an applicant for asylum shall not seek or enter employment or carry on any business, trade, or profession during the period before the final determination of his or her application for a declaration. The applicant was offered employment in his direct provision facility in 2013, but when he applied to the Minister for Justice for permission to take up that employment, the Minister refused on the grounds that such employment was precluded by Section 9.4. Accordingly, the applicant commenced proceedings in which he argued that Section 9.4 was unconstitutional. This claim was dismissed by the High Court, and that decision was upheld by a majority of the Court of Appeal. Leave was granted to appeal to the Supreme Court, which unanimously held that Section 9.4 was after all unconstitutional. The judgment was notable for a number of reasons. The applicant in NHV asserted his constitutional right to work. This right is not expressly protected in the Constitution, but has been recognised as an unenumerated right in a number of previous cases. O'Donnell J. added that to deny any protection to the applicant would be to fail to treat him equally as a human person. The unenumerated right to work in any case is one of the most detailed considerations of the contours of an unenumerated right in the past 2 decades. This case proves that this doctrine is very important and therefore should not be abolished. In this case, the plaintiffs challenged that the constitutionality of a decision to grant the extended planning permission to the Dublin Airport Authority, the High Court refused standing. The plaintiffs, which included multiple persons and the organisation Friends of the Irish Environment, sought to challenge the decision of Fingal County Council to allow the DAA extended planning permission to build a third runway at Dublin Airport. The plaintiffs contended that such development would have an adverse effect on the local environment and that the public should have been permitted to participate in this decision. They argued that an implied personnel constitutional right to environment that is consistent with the human dignity and well-being of all citizens. The High Court refused to grant locus standi to challenge this decision on the grounds that they enjoy no standing under current legislation, namely the Planning and Development Act of 2000. The extension of the planning permission was one that could be made without consulting the public, meaning there was no right of participation in the process. In the view of the court, there was a failure to establish that there was a threat to personal constitutional rights under this legislation, and as such, no locus standi could be afforded. The effects of the doctrine have been the cause of significant controversy over a prolonged period of time, with critics such as Oren Doyle describing the doctrine of unenumerated rights as having withered, and David Kenny, writing of the demise of the doctrine, describing Article 40.3 as having atrophied. However, the notion that the Constitution protects unenumerated rights that are inherent in the human personality is suspiciously similar to natural law. Natural law theory, as espoused by the Irish courts, holds that people have inherent rights by virtue of their human personality, and it is notable that over the past 2 decades the Irish courts have all but abandoned reliance on natural law in its constitutional adjudication, and therefore I believe that this doctrine should not be abolished.